He should be possibly demoted and be retrained and moved to a different shift. And then I was told after that session that self-predicted real part of that also. And said that, basically, well, I can't say he said because I was not there, but I implied that he didn't feel like he didn't know, so didn't you retrain after watching this video? And the only option after that's termination.
But you could force them to be retrained.
I could force him. Also, back to the offer of going to the first shift and being retrained. That necessarily doesn't mean we would sit in this courtroom a couple months from now. Being retrained means you have to be retrained, not just sit through training and get the strong about it. You have to show some improvement, last improvement. So that offer gives guaranteed improvement for through the process of retraining. You would have to be retrained properly and show that you have capabilities as a police officer. So even if we accepted that offer, 3 months down the road, we might be sitting in the same floor.
And why the lower rank?
Because he also didn't show sergeant material. I could provide other instances too, just illegal.
So you wouldn't want somebody that behaved the way that he did on Devin Lyons' video to be the supervisor of other officers?
Absolutely not.
What makes you think that he's unwilling to be retrained?
He didn't lie. He's implied that he didn't do anything.
So if you were willing to keep Sergeant Higdon on the road as a road deputy before, why are you seeking termination now?
Because of the lack of wanting to be retrained, and then even if I'm forced him to. It makes more of this more.
So if you have a lackadaisical officer, and that was going through retraining, you don't think that would have a
That's the question again, I'm sorry.
if you have a lackadaisical officer, to go through training, you don't think that there's gonna be any benefit, there's real remedial,
I think doesn't want to be there.
someone who disagrees with the administration, the policies of the
administration.
the policies of the administration. Will Sergeant Higdon lose suspension if he's terminated?
No.
I'd ask that the board be instructed not to consider that piece of testimony and that it be stricken. I don't think that the financial impact or lack thereof of termination should weigh on the decision of whether termination is warranted.
I think earlier you had asked some questions of your own client with respect to how this would impact them from a compensation perspective. So because of that, maybe I'm going to go ahead and allow me to answer.
Understood.
Okay, thank you.
Sergeant Higdon testified that he does not think that he did anything wrong in any of these 3 incidents. He also testified that he does not need to be retrained. Can you explain to the board why termination is the only option?
For everything I just read. We did nothing wrong. I think on every scene as a police officer, especially in chaotic scenes, I think it would be your body camera and say, I could have did this better. I could have did something smaller better. But this was a huge failure to happen. When you hear the shots, but I wasn't there, so I don't know what they actually sounded like. I don't know what they sounded like on the body cam. It could have been a taser. It could have been a gun. You can't see two officers with a known combative subject. When you hear two shots go off, did the guy get the taser from him and tase both officers? Did he get a gun from him? Did he have a gun? And then when it does happen, okay, I understand you're behind or you're taking the high ground, make sure you double back. Police officers, when you hear fire, gunfire, taser fire, you run toward that. Especially when you know you have two subordinate officers and you down. And you're the one who wants this to.
I have no further questions.
Good morning, Sheriff.
It's more.
So, when there's an internal, you reviewed Tom's body cam from the August 2025 incident involving Devin White.
Yes.
Did you review Officer Freeday and Officer McCutcheon's body cam?
I believe it was McCutcheon's. I reviewed one of those.
One of the two.
Yes, sir.
And I've been down this path a lot, but are you satisfied with the use of force that Officer Freeday engaged in there?
Yes, it fits our policy, but it doesn't have anything to do with this hearing.
In what way does it fit your policy?
That we have this active, knowingly resisting person that has some mental issues, that's rather large in stature, that could possibly, from my understanding, the parents or the guardian said they could be in danger from him, actively resisting that things are fit.
Actively resisting what?
Our officers and their commands.
And what do you believe was their legal basis for commanding him to stop?
That he had a mental issue and possibly could be taken to the hospital.
And do you believe that's the standard for officers to detain somebody and take them to the hospital?
Yes.
Okay. If you're wrong, it's because the taser use was according to policy, doesn't it?
I'm gonna object to that. I think the issue is not before the merit board. There's been no internal investigation on the use of the tasers.
We didn't stipulate there's been no internal investigation. It's before the board because part of what we're trying to prove is selective enforcement. And Officer Freejay's violation of the use of force policy was much more serious than any violation that Tom was accused of.
But he didn't violate the use of force policy. There's been no determination.
We're gonna disagree about that, and that's okay. We go to make that argument. But I get to put on evidence about whether or not there was an investigation into the use of force and how they came to that conclusion. And if they came to the wrong conclusion about whether or not the officers had the right to detain Devin Lyons, then it would follow that it was outside of the procedure for use of force.
And it also would have nothing to do with Sergeant Higdon's merit board.
Again, it has to do with selective enforcement.
I understand the defense. I think it's already in the record that there was not an investigation done, a finding with regard to the use of force. So what is your question?
My question is, if the sheriff is wrong about whether the officers had a legal right to detain Devin Lyons, does it then follow that Officer Freejay violated the use of force policy?
I think that would be a legal conclusion. That would be the decision of another decision maker.
Okay, I would argue to you that as the person who's in charge of training and enforcing these policies, that this witness is entitled to have a conclusion and an opinion about
And
that.
I think he's given that. I think he said he thought based on what he saw that they operated within policy. So I think he's answered the question. For him to then say that somebody else determined legally that he's wrong, I don't think that that's what's before in the airport.
You testified that Tom said he didn't need to be retrained.
Yes.
But he said it to you.
Uh,
Who told you that?
My chief.
And when did your chief tell you that?
After the investigation was initiated and completed, and he spoke to me.
And when did your chief tell you that Tom had indicated that to you?
I don't know the name.
But whatever day it was, the day that Tom told that to your chief, your understanding is that's the day the chief told you.
Yes.
Whatever day that be.
I don't think so.
And is there any documentation of that anywhere in your file?
I don't believe so.
Okay. But that's the crux of the whole thing, that he's not willing to be retrained, so he must be fired, but we didn't document that.
Objection is documented in the formal investigation.
You can show me where, I'd be happy to withdraw the questions.
Is it in the record?
I mean, Sergeant Higdon testified that he didn't want to be retrained.
I know what he testified to, but there's no indication in the investigative record that he had said that he would not be retrained at any point during the course of this investigation.
Yes, so that it may, I did misspeak, it's not in the investigatory record, but I don't know that, they did the charging update, they made him an offer and he refused it. So
Well, the offer wasn't just for retraining, and the decision to pursue these charges cannot be based on his testimony while we're having a hearing about the charges. That's temporally impossible. Now, so if the refusal to be retrained is the sole reason we're here, and there's no documentation of him saying it, except they're alleging that he said it on the stand, that can't have been the reason they made that decision.
I'm not sure that the record reflects that the refusal to be retrained is the sole reason.
No, his testimony was that was the reason.
That was the sole reason?
That was essentially the deciding factor, that there wasn't any point trying to retrain somebody who didn't want to be retrained, I believe was the thrust of the sheriff's testimony.
That mischaracterizes the testimony. The reason that we're here is that he would not accept a temporary demotion, would not go to days, and would not get.
That's the first I've heard of the demotion being temporary.
I didn't mean to say temporary, I did, sorry.
Whatever you say, that's what I'm gonna do.
Okay, well, I appreciate that, Mindy. I think you can ask him what the basis was for where he got to where he landed. Because I think that the evidence is maybe a little bit confusing on that one.
Whatever the determination and the reasoning was, there's not any documentation in the investigative file that Tom had refused retraining as a standalone proposition, is there?
Don't believe so.
Don't ask them. You're gonna testify that way, you know. You offered him a demotion, or rather, you offered to let him agree to a demotion and retraining and changing the shift. So he would continue to be a law enforcement officer. And every danger that you knew about that he presents to public safety and the community and fellow officers, that would also have applied when he was on the road as an officer during the day, wouldn't it?
Be inaccurate about that. The retraining would have to be successful for him to be able to continue his job as a police officer.
And in the course of saying that, you said that there's no guarantee that if you'd done that we wouldn't be here a few months further down the road if that training didn't go well.
Correct.
Did you know it's the same thing the chief said half an hour ago?
Okay.
Okay, did y'all talk about it?
No, we did not talk about that.
Okay. You answered. You said it's not very good forcing someone to go to training who doesn't want to be there. The outcomes are not particularly good there. Is that correct? Every officer you got is forced to go to the Indiana Law Enforcement Academy, right?
Correct. Except for the reserves.
And the standard training that everybody has to do to maintain their qualification to be a law enforcement officer, that's all mandatory, isn't it?
Mm-hmm.
Doesn't matter whether they want to go or not.
Correct.
It's important that they go anyway.
Important that they go and they complete it, yes.
Better to have them do that, not whether they want to be there or not.
And I would hope I would hire a police officer that wouldn't want to go. But I would also say that there's police officers that probably don't want to go, and they probably don't turn out to be good police officers.
When was the investigation into this matter concluded?
I don't have the date.
Okay, do you remember approximately when?
December.
Okay, December.
I'm assuming.
When did you first become aware that Tom was supporting your opponent in this year's election?
I believe it was either a fundraiser at the St. Harbor Church, or it was the 4-H fair last year
4-H fair was in June, right?
in July.
Usually in July, moved it to June last year because of the heat, right?
No, it's because of the different machine.
Different reason, but they moved it to June last year. When was the fundraiser, the other fundraiser you talked
That
about?
I don't know. I don't know before or after the.
But no later than June of last year, you did.
Yes.
Tom been working for the Clark County Sheriff's Department for 35 years.
Correct. Yeah, I think so.
And aside from a couple of minor write-ups for tardiness, or getting counsel to turn in some more reports, he never had any serious disciplinary action taken towards him prior to that, had he?
I don't believe so.
Okay. Is this firing political?
Absolutely.
When you all engage in an internal investigation about a complaint, you hand the officers who are questioned a letter saying this is a confidential matter, you're not to discuss it with anybody other than the chief, the assistant chief, deputy chief.
Yes.
What's the purpose of that?
I guess to protect the integrity of the investigation, so to prevent gossip between the department and things like that.
And similar to a criminal investigation, you have the discretion to not release the materials of an active internal investigation in response to a public records request. They're confidential, right?
I do have the discretion.
You can, somebody brings a FOIA request and I want those materials, you can say, no, that's an active investigation, they're not public.
Or I can say yes.
Right, but you can withhold those things that would otherwise be public records for the interest of preserving the integrity of the investigation.
Yeah, I could.
And you tell all your officers to abide by that principle and not to talk about the investigation or what they've discussed or any of the materials while the investigation is going on, other than with the leadership of the sheriff's department.
Right.
When did you post the body cam footage from the August 2025 incident on Facebook?
I don't have the date, but I can give you a rough time. It's probably about 2 weeks, 3 weeks after Kurt Higdon, Sergeant Higdon's brother, made a campaign. I call it a campaign on the Facebook page, releasing all the information, or releasing some of the information that Holmes and stuff did not do by the time we were speaking.
Do you remember when that was?
I'm saying it's about 2 weeks before I made my post.
Okay, but that's just to refer me back and forth from one to the other. Do you remember what month it was?
December. Right, I could be incorrect. I don't have my phone with me. I keep dates on my Facebook posts in my head.
Is there any policy about the sheriff's department accessing or using social media to communicate with the public that you have in force at the Clark County Sheriff's Department?
I believe there is.
And what's it say?
I'm not.
Okay, you don't know the policy. Is that right?
I know there's a policy about speaking about the department, illy, there's other things in there. I mean, if you want me to memorize the policy, I guess.
I'm just asking if you know. I'm not accusing you of anything wrong if you don't know about here. Okay. And if I told you that you posted the video and a long commentary about it on December 4th, does that sound accurate to you?
Yeah.
The investigation still going on then? Let me ask it a different way. When's the investigation concluded? So, formal. I guess so too. So the investigation's still going on.
Correct.
Okay, so we can agree that that was posted on Facebook while the investigation was going on. And what Facebook site did you post it on?
Very like Scottie Maples.
Say it again.
On its
Say it again.
face, that is a platform that's not an official organ of the Clark County Sheriff's Department, right?
What it is now.
Well, the board was named re-elect for Scottie Maples for sheriff. It was Sheriff Scottie Maples, which I moved to push out all sheriff information pertaining to the office.
What was he named on December 4th of the last year?
I just said reelect Scottie.
Okay. And does the sheriff department have a website that's hosted by the county?
Yes, we have the website.
Okay. But you put your information out on your own private Facebook page.
I think private is public.
In what way is it public? Is there government oversight over what is posted there other than yours?
It's so public, I can't delete people's comments off there, I can't block people.
We're using the word public in different ways, and let me try to clarify. When I'm talking about private or public, I mean that website, that social media page is not controlled by any government entity. Is that right?
No, I'm just not.
Okay. And as it's titled now, as it's titled on December 4th, when we publish information about this investigation, it advocates your re-election for sheriff. Right?
Some of the posts do.
I'm not asking about the post. The page itself is titled Re-elect Sheriff Scottie Maples.
Yes.
Okay.
I am the sheriff.
Now, well, first, come on, hi, Lori. Okay. I'm going to go ahead and hand you what I'm going to have to mark and admit as respondent I'm going to represent to you that these are screenshots of your post and of where you posted the body cam video on December 4th. Does that seem accurate to you? Okay.
Are you going to put this in evidence?
I am.
Okay. Any objection to that?
I have not seen this yet, so I guess I would have to confirm.
I will tell you, that's what you provided to me in response to my request
this
for any of
is-
his
I'm sorry.
social media posts.
I thought you said that you had comments on this, so I had.
No, I don't think there are any comments on there.
Okay.
So we will show exhibit I admitted without objection.
Now, are you familiar with Indiana Code 3-14-1-17? If I told you the title of it, use of government employers' property for soliciting contribution, advocating election or defeat of a candidate, or advocate approval or defeat of a public question. If I tell you the title, does that refresh your recollection? You know that statute at all?
No, but you would have to absolutely slow down when you kept speaking about it. And then speak here.
I'm a fast talker. Are you a government employee? Okay.
I'm what?
The statute says, and I'll try to be nice and slow, a government employee may not knowingly or intentionally use the property of the employee's government employers to do any of the following: solicit a contribution, advocate the election or defeat of a candidate, advocate the approval or defeat of a public question. Then you skip down to the end. A government employee who violates this section commits a Class A misdemeanor. However, it's a level 6 felony if you've done it before. Now that I've told you the content of the statute, is it in any way familiar to you?
The statute? No, I understand what you read, but I've never read that statute before in my life.
You've been along for quite a while, right? Is it a requirement that a person know what the law is in order to be in trouble for breaking it?
Objection. This has nothing to do with this murder proceeding.
It absolutely has everything to do
He
with it.
doesn't have to know every,
That's his job.
That
That is his job.
But, go ahead.
I am going to offer the statute as J and ask it to be marked and admitted.
Okay.
It's not evidentiary material, it's a statute, but in order to provide it to the commission and make it part of the record, I'd like it to be.
Okay. Any objection to J?
No objection.
Okay.
But I am gonna object to any questioning about the witness on any criminal matters. I mean, well, this is not the right tribunal for that.
It goes to character.
May I respond to the objection?
Yes. First of all, before you do that, we'll show J admitted without objection.
The officer's testimony, the sheriff's testimony, indicates that he took government material from an investigation being conducted by the Clark County Sheriff Department regarding Tom Higdon and the request to terminate him, which we're alleging was a politically motivated decision, and posted it on his reelection page, which he admits and has testified to. And the only thing I'm trying to follow up on is not only does that evidence political motivation and bias, but what the statute shows us is that he was willing to break the law and commit a crime to do it. Whether he knew it was a crime or not is a question that he's now answered, which I did not know, which is why I asked him whether not knowing the law is a defense to whether you've broken it, which I think the legal conclusion, we know it's not, but I expect the sheriff knows that too.
That doesn't go to political motivation.
Willingness to break the law to put government material about this process on his reelection page absolutely goes to motivation.
I think the question, if I understand it, was, can somebody break the law? Basically, is violation of the law or ignorance of the law defense? I think that's
That is my question,
right? Okay.
yes.
Okay, so do you know that? Is ignorance of the law defense? If you know that or not?
I'm sorry, you saying you don't or no, it's not?
No, it's not. That's.
Okay. The Indian Code also has a code of ethics. It says the code of ethics must, except as provided in subsection C, prohibit a state officer, employee, special state appointee from using state materials, funds, property, personnel, facilities, or equipment for political purpose. Are you familiar with that statute?
I'm not.
Now that I've read it to you, does it seem to you that by posting confidential investigative material about this investigation on your re-election page that you've committed an ethical
I'm
violation?
gonna inject the commenter in that as well. This is not the tribunal to decide whether or not the sheriff has committed an ethical violation.
Well, I think he can give an opinion of whether or not, based upon what he knows about that ethical rule, he thinks that what he did, that he believes that he
I'm
did.
not gonna identify something that, not before the right tribunal.
Well, I just asked to be reserved the question if we should have to kick it up with the trial court now.
We can note the objection and instruction not to answer for the record, and that can be considered.
Make him plead the fifth.
You posted and published the first amended affidavit charging Tom on that Facebook page as well, didn't you?
Yeah, that's probably not.
And you posted it on your re-election page. That is not the charging information that we're here for the Merit Commission to consider, is it?
Change.
It did change. It got quite a bit shorter. It was 18 pages when you posted it.
Right.
And now it's 2 if you don't count the notary signature page. Trimmed down quite a bit. Is that right?
My counsel didn't.
So who drafted the first amended information? The first amended information, the one that's been superseded?
The one we're currently reporting.
No, the one that you posted. Who drafted that one?
I believe it was my counsel responding.
Okay. You signed it.
Right.
You signed it under oath.
Right.
And you posted it on your re-election Facebook page. And among other things, in that first amended information which you published and commented on, you accused Tom of cowardice.
Right.
He's no longer being accused of cowardice, and that's not something that you're seeking to prove here in front of the board. No longer on the charge, yes. Gonna hand you what I'm gonna have to be marked admitted as K, because of the way I copied it, it's redundant, because I have both the second and first amendment charging informations here together. So why the change?
But we obtained core counsel, Cynthia joined. And after, having a meeting with her, it was her suggestion to me as counsel that it should change to this.
Well, and I do not want to hear anything about what advice you got. That is subject to attorney-client privilege. I'm not gonna ask about it. If you think I've asked anything about it, that's my mistake and I don't want to hear about it, okay? But, leaving aside anything that might fall into the category of advice you got from your lawyers. You changed it because you couldn't prove he was a coward?
No.
You did not. Calling somebody a coward is about the ugliest thing you can call them, at least the language you can use on regular TV, right?
I'm gonna object.
That would be your opinion.
He doesn't call
Well-
it a coward in the charging affidavit, he say that I mean, let's use the actual language of the charging affidavit.
I think the witness answered that his counsel's opinion and it wasn't something he said, so I think he's answered the question.
Yes. Let's hear it, Scotty. Please don't lie to us.
Sheriff, what's the LERM system?
I'm sorry, could you hold on for just a second? Was this?
I'm sorry, I gave you I'm so sorry.
Oh, that's
I gave you a whole stack of copies. It's the second amendment charging information, and underneath it is the first amendment charging information, and then there should be 6 copies of it, but they are not subdivided. And if you want me to take a minute and do that as I should, I'd be happy to.
That's okay. Are you?
And that's something that is used by all the Clark County law enforcement agencies, right? Okay. And what to do?
Basically, where you put in the information or any kind of case report or investigation into a database.
And then all the law enforcement agencies working in Clark County, except for the state police, have access to that database.
Unless the report's filed.
Okay. Are most of the reports locked or not locked?
Now a lot of our reports are locked.
The majority of them?
I couldn't say, but I don't keep very many reports to share.
When you're talking about being more reports locked now than were, you're talking about from the Clark County Sheriff's Department reports and all the agencies that use the alarm system in Clark County.
Yeah, I've seen, none of Jeff City's locked, but in Clark County as well.
But if they're not locked, all the agencies other than the state police can get on the system and look at those investigative files.
Yes.
You look and see if somebody has a warrant, right?
Yes.
The CAD system runs off of it, right? All the information in it.
The alarm system and the CAD system are owned by the same entity, but they're two separate folders.
No interplay between the two?
There's everything, yes.
Okay. How long have you all been using the alarm system?
You need to get the data on that, this one over at.
Has it been more than 10 years?
Yes, that's it.
And during that time, have all the agencies in Clark County, other than any of the state police, had access? Is there a period, beginning of last year and the year before, that you restricted an agency's access to the alarm system? Specifically, you shut off the alarm system access to the Charlestown Police Department.
Yes.
Why'd you do that?
Well, we were working this may be a long answer for you, Mr. Weber, but I'll give it to you.
Actually, I'm gonna sort of objection, how is this relevant? Can you give us an access?
Well, testimony's gonna be that Sheriff Maples shut off the Charlestown Police Department's access to the alarm system without telling him he was doing it. When he had a meeting with the Chief of Police of Charlestown Police Department afterward, he indicated that the reasoning behind it was because an officer of the Charlestown Police Department had access to Clark County Sheriff's Department investigation into a murder case, and he believed that that officer was leaking information to his political opponent, and he believed that based solely on the fact that his political opponent happens to be married to the mayor of Charlestown. He put the safety and efficiency of Clark County law enforcement officers at risk because of a perceived political threat, which is demonstrative of a pattern of political retaliatory behavior, just like his decision to try to fire Tommy.
I would not think that has anything to do with this variable hearing and these actions.
Well, I think it goes to the defense that's being raised, that this is being politically motivated. And so to the extent that it can be focused on the defense of political motivation, I think it's relevant.
So, was the decision to cut off Charlestown's access to the alarm system politically motivated?
No.
Okay. And you never expressed to anybody Charlestown Police Department or otherwise that it was?
No. You also said that I had a meeting with the chief before, and that's it, that was an accurate statement of.
Well, you saying that didn't happen. You didn't meet the chief of Charlestown Police at any point?
Met with him once at the Grand Park Schools about an incident, and about this incident, me suspending temporarily the learn system, I did not.
Okay. The incident you mentioned where you did meet with him, that had to do with a call alleging there was a live shooter at Charlestown High School.
Yes.
Charlestown High School is in Charlestown, right?
Correct.
And the school resource officers at Charlestown Elementary and Charlestown Middle School are Charlestown police officers.
Correct.
But the school resource officer at Charlestown High School is the Clark County Sheriff's Deputy,
Correct.
Kevin Fisher.
Yes.
You had occasion to meet with the Charlestown Police Department, the chief, following the call that there was a live shooter at Charlestown High School.
Correct.
And at that meeting, you were informed that they went out on this call, all the officers, who were met at the front door by Officer Kevin Fisher, who didn't have his radio on and was on his phone. Is that right?
I believe it's the principal and Officer Fisher,
Okay, both of them then.
and I can't testify to the phone.
But that's what the Charlestown Police told you, didn't it? Okay. And there was never any internal investigation as to Deputy Fisher as to whether he did in fact have his phone out or have his radio off in that live shooter report, right?
I have no information that says that Kevin Fisher did or did not have it very long.
And had there been an internal investigation, much like this one, and a disciplinary complaint like this one, that would have come to you.
Yes.
And so, in the absence of you knowing about it, we can conclude that there was never any disciplinary action or any investigation. Is that right? Okay. You're also told that Kevin Fisher physically barred the Charlestown Police Department from coming into Charlestown High School to investigate whether there was a live shooter, weren't you?
It was the principal with the assistance of Kevin Fisher.
Okay, it wasn't just him, but the only one you have managerial responsibility for is Officer Kevin Fisher. And similarly, there was never any investigation or disciplinary action for Officer Fisher preventing the Charlestown Police Department from entering the school and seeing whether there was in fact a shooter in the high school.
There was no investigation because I spoke to Kevin Fisher and he said that he had made a phone call, so he may have been on the phone at some point during when Charlestown showed up, and he was trying to de-escalate the situation because there was no active shooter. He had already cleared that out. There was a phone call from Ivy Tech that was completely incorrect, saying that from a kid saying that they thought somebody had a gun in the school, and Charlestown police went to run in there ununiformed with rifles when they were letting the school in the middle of break. Kevin Fisher made an excellent decision that day.
So it sounds like you know a lot about it. Actually, you looked at it and decided it was absolutely fine. Not there wasn't any looking into it at all. Which is it?
Kevin Fisher did absolutely nothing wrong that day.
Okay. And at the meeting you had with the chief of the Charlestown Police, he felt differently.
Yes.
And is it correct that at that meeting, you again accused
Usually, I stated the fact.
what fact?
I stated the fact that we scheduled this meeting, I believe, the night before, and for some reason, Ed Byers posted about it that night. And I don't know why he would be posting about it if I only talked to Chief Cruz in the program, high-level administrators, and then we have somebody posting about this meeting. What do you think something got leaked? Or
What's that got to do with whether it was an appropriate activity that was taken to address the call of a live shooter at the high school?
I don't understand the question.
What does somebody getting information and putting it out in the public have to do with deciding whether or not the appropriate response to a report of a live shooter was made? Why is that the concern?
it was a meeting where we needed to come to a clear, concise conclusion on this. And I found it very, we talked about it with 3 people, and then I see a post about it later that night. And I was also told the day of the alleged shooter, that when Chief Cruiser had left, he was upset. He said he was going directly to the mayor's office.
You heard him say that?
No, I was told that. He said,
By whom? Okay.
Maybe if you would, could you get to your point, because I'm starting to not understand everything.
I'll move on. You elected in 2020, took office January 2021. I'm sorry, you were elected in 22, took office in 2023. Your immediate predecessor was Jamie Miller.
yes,
You were his chief deputy.
yes, for 2 years.
And essentially, he supported you, handpicked you, said this is the next sheriff.
Yes,
Campaigned for you.
yes.
You all were close.
It would appear we were.
Would it be that for you?
Personally?
Yeah, did you think you all were close?
No.
Okay. But you can understand why the world at large would see it that way.
Absolutely.
Okay. A lot of us know to one degree or another, but what happened with Jamie Hill after he left office?
I put him in prison for 12 years.
With some help. You didn't sentence him.
I'm sorry, I got people in the crowd cussing. You might want to take care of this.
If we could, please not be commenting. If you can't sit and refrain from commenting, I'm gonna ask you to leave the room. Okay, so let's all be respectful of the questions being asked and answers and listen. Thank you.
When you say you put Jamie Hill in prison, what do you mean?
I called Indiana State Police, fully cooperated with them. Finally, uncovering something that I had no idea about, who Jeff William Hess, which led to 27 unmoved felony counts, 26 of them here to be Jeff William Hess. John never been associated with in my life, and he's been paid for with in my life. He's our charge criminal did one felony at the Clark County Sheriff's Office. That was gross employment for maintenance worker working in his firehouse. If I wouldn't have made that phone call, Jamie Hill's still be out there selling them $2.
Tell me about the phone call. Why did you call the state police?
Because I found that my office was wiretapped.
Mm-hmm.
His brother-in-law trying to file that happened on Jamie Hill's watch. On my watch, I caught his brother-in-law, filed for a fake pension.
When was that?
That was in 2023 after I was sheriff. I caught that.
Was that before or after you made your call to the state police?
Before.
Okay.
And then I'm gonna,
Go ahead.
and then, I had a maintenance worker tell me that he told me, he thanked me for letting me do his job. And I asked him what that meant. And he says, I had to redo all the floors and all the chapel, firehouses. I had to do personal work at Jamie Hill's house. And I said, I had no idea that. And so that's why I called the state police.
How did you come to find out that this maintenance worker had been doing work for New Chapel?
Michelle, I can have an objection. I don't see a nexus between.
I would tend to agree with that. I don't see what happened with the precinct chair having anything to do with what happened on August 24th, 2025, and the 2 incidents in September that are part of this proceeding today.
Well, if I may, it's a convoluted process, and there's going to be a certain amount of background we got to get through before the relevance is immediately apparent. But our position here, our defense here, is that this firing was politically motivated, and that it in part stemmed from the ongoing willingness of the sheriff to place his political interests in front of his duties as sheriff, and that in turn all stems from his own perceived political vulnerability based on his close ties to our previous sheriff, who is now serving time at the Indiana State Prison.
I'm going to ask you to move on.
I'm going to ask to make an offer of proof on this. I have to have this in the record.
That's fine. If you want to put something on the record, preserve it later, then you can do that.
I can't do it later without the witness.
Nikki, I mean, we're really getting out there with things that one predated the basis for the charges here today. I mean, if we're gonna start going down the road of what other people did misconduct wise, that has nothing to do with us or Higdon, then
Well, what it has to do with, again, is the political motivation for the termination proceeding. And in order to understand that, you have to understand the politics. And in order to understand the sheriff's politics, you have to understand the last sheriff's politics and how he became a political liability after he got Sheriff Maples elected.
And I put Jamie in prison, he's a Republican.
I'm gonna sustain the objection. We're gonna move on.
You didn't discover any of this wrongdoing until after you got elected. And you said it was one maintenance employee out there?
We're not gonna go down this pathway of
For the
city
purposes,
sheriffs and the things that have already been litigated, adjudicated. We're gonna focus on the things that are subject to charges here later and all that stuff.
for the purposes of the record, not taking exception to the ruling, and I'll move on.
Okay, that's fine.
Now, this investigation, in addition to publishing the first amended charging information and the body cam footage, you made a fairly lengthy comment about the proceedings and about your opinions about it.
Correct.
And I believe that's in evidence as I or J, is that right? Is that one of the things I already showed you? One of the documents was your...
I think it's I.
My post?
Yeah, your post, that's one of the things I showed you. You put in there that Sergeant Higdon didn't know if the noise was a taser or a gun. He never said that, did he?
No.
And you weren't there.
No.
You don't know whether he knew that was a taser or a gun or not, do you?
You ain't, body cam footage, I'll let you know.
Okay. You wrote, he didn't get on the radio because he didn't have it turned on.
Correct.
You aware that the investigator that you put in charge of investigating this has testified that he didn't know, couldn't conclude whether or not Tom had his radio on?
We went out to the, brother tested it. But, okay, I can see that.
Okay.
I know you did, from your finish answering your question, I know he didn't attempt to get on his radio.
Okay.
Even if the radio was.
But you posted an affirmative representation that he didn't have his radio on. You made that representation to the public at large on the largest platform you had.
Also, the person that went out there and tested the radio were perfectly fine.
Were they out there on the day that the incident we were talking about?
No, they were also.
And did you review the investigation materials and the reports produced by your investigator before you posted your street on Facebook? You go on to say you wrongly accused the same deputies of stealing from a vehicle. Accusations that were proved false by simply watching the body cam footage. You didn't mention that he's the one who wanted to watch the body cam footage, right? You didn't mention it. Once he saw the body cam footage and got to the bottom of it and confirmed what had happened, he acknowledged that they hadn't done anything wrong and didn't bring any kind of formal complaint. You didn't say anything about that, right?
Yeah, I didn't say anything about him breaking police officer's bill of rights. You're correct.
You wrote, I can't ask deputies to put their lives on the line if they can't trust their supervisor to come running when things go wrong. Right?
Yes.
You didn't write in there that you'd offered to let him remain a police officer.
And be retrained. And be successfully retrained.
Well, and sorry talked about that, I'll leave it alone. Going back up, you took close in front of you. You wrote, once he arrived, the two deputies went into the woods to look for the suspect. They found him and a physical struggle quickly started. During the fight, which lasted several minutes, the deputies had to deploy a taser to get this man under control and in handcuffs.
After a physical struggle, they had to.
You watched the video, right? I need you to say yes for a
Yes.
Was there any physical struggle before the first phase?
No, I would say.
Because there wasn't one until after the first phase.
It's speaking to the physical struggle that had to deploy the second taser.
Okay, but that's not the way you framed it in your post, is it? You said there was a physical struggle that went on for several minutes and resulted in them being tased.
It was a physical struggle.
But not until after he'd been tased.
The first time appeared to be ineffective and clearly getting under control.
Okay, but it was effective in getting the face down on the ground with one arm behind his back, wasn't it?
Yeah, but that didn't work.
So, you got a man with no weapons, no
You
shoes.
don't know that. If you're out there.
You know it now.
Yeah, I know it now.
And you know that the call that had come in was that he didn't have a weapon. Or did you?
I believe she said there possibly could have had a knife.
Well, let me have, I think it's H, or no, it's earlier than that. Castle. This is way back in the way. This is respondent's A. This is the CAD report.
CAD report. That's true.
I haven't asked you a question. There you go. Look at the entry from 653.50. Oh, 653.15 from the CAD report from that instance. 653.15.
No known access to weapons.
So that's in the CAD report. There's no known access to weapons.
No, yes.
And that directly contradicts what you just said. You believe that she said there might be access to weapons, doesn't it?
These are CAD notes that are put in by dispatchers. Quickly, obviously. There's another one in 30 seconds. Then another one in 4 seconds from them.
So do you have some independent reason to think she might have said something that contradicts that, if there was a weapon involved?
Dealing with the other Mayans and all the history of the
I'm asking about what was said, not what you know about Devin White.
I think you always think when you're dealing with a suspect or a person like this that they may have weapons, going in as a police officer.
But you're willing to acknowledge that the only information that they had about it on the day was there was no known access to weapons.
I don't know, I wasn't there.
I'm not asking you if you were there. I'm asking you if that's the only reference to weapons in the information that's documented from the incident.
So if we raise that question like that, then okay, yes.
Okay. It also says in the CAB report that he's not been physically aggressive yet.
Yeah.
And I understand that's not a guarantee you won't ever be. It does tell you something about the situation on the ground, doesn't it?
Yeah.
Okay. And it works to the extent that he goes face down onto the ground and they get one arm behind his back. And it works to the extent that he's laying there pretty much immobile. He's not moving, right?
No, yes.
Okay, we have to watch it then. Is your flash drive still in here?
It's not like we did.
Right, so clerk have their copy or?
Yeah.
Okay. Oh, no, I'll talk there. So, you're laying there face down on the ground, right? Officer Free J and Officer McCutcheon each had a knee on it. You can see that in the video. Right. He's talking to them in a relatively mild tone of voice. Is that fair? Says, I don't understand. You heard that? Yes. Said, please can I get up? Can I just stand up? He said, I need help. Did you hear him say that? Okay. Is it fair to say that your characterization on your re-election page doesn't look anything like the video we just watched?
I'm not sure.
Well, let me phrase it a different way. Did you get on Facebook and lie about what was in the video? Okay. So, when I was asking you about the CAD report and where it says that there's no known access to weapons, you told me that as a law enforcement officer, you always assume there could be weapons involved. And so you treat everybody accordingly. You make sure they don't have weapons or access to weapons as you're dealing with it. So when was the right time to search that line after they had took handcuffs on him?
Handcuffed and stable, and to a safe location to do so.
And do you know whether they did that? Do you know it's in the video? Did you watch the video to the end? Okay. Yes. Well, that's easy because it's right at the end. What's the time on that?
That's all good. I don't see the mention and stuff. It's true.
Okay. Well, there's no. So this is 7:27 p.m. and Devin's in there in the ambulance with EMTs, right? Yeah. And the second tape, and I didn't ask you to look at it, but if I told you it was 7:17 or so, does that sound right to you?
If that's what you said.
And I'm still early because we got to go forward to.
Yeah. So, yeah, definitely. We're gonna. That's good too. I guess the shoes are gonna put on too, right? That stays up for me. Try to fix that one. Do something. When I take this stuff, like, you just leave your hand on top of your head, okay? You understand? Yeah. Yeah, she dangled up here, I'm like, basement.
15 minutes after they put him in custody. Is that right?
1732, is that what it says on
Yeah, it's in 1932.
there? Okay, yeah.
And it was after they left him, that's where they encountered Tom coming back from that, where they detained Devin Lyons. Which one of them seemed more distressed to you?
I'd have to look at Tom's body camera.
We can do that. I don't want you to lie to me.
Sergeant Higdon.
Okay. So there wasn't any reason for him to check on either one of those guys.
He's the sergeant.
And they're fine, aren't they?
That, I would say if I had to pick between McCutcheon or Frege, I would pick McCutcheon. McCutcheon seemed more out of breath.
Is being out of breath something that's going to put one of your officers in some kind of danger?
Potentially.
Okay. Say, you testified that despite public appearances, you and Jamie Knoll weren't that close.
Correct.
You know he's watching on Zoom yesterday from the Indiana State Prison?
That, you could log in under any name. I would assume that was a joke.
They got tablets in prison, don't they?
Actually, I've never been in Newcastle prison, so I cannot answer that question.
Here we go.
That's ridiculous.
I can't wait to excuse him at the ballot box.